Hello, this is Mr. Seymour, and this is going to be Chapter 3 of your lecture series from the textbook American Politics Today. And this chapter is covering the topic of federalism. The question of federalism is, should the government require, for instance, all Americans to have health insurance? While individual Americans disagreed about this question, the states and the federal government also disagreed about the role of the state in implementing the Affordable Care Act, or Obamacare. Now, this is just one example of the issue of federalism. Federalism is investigating the relationship between the state and the federal government. Federalism is a system that gives some sovereign power to state governments and some sovereign power to the national government. It's a system of government that divides sovereign power across at least two political units. Because the national government and state governments may have different policy preferences, battles over the balance between federal and state power are inherent in our federal system. In 1981, 29 states and the District of Columbia allowed either 18-year-olds or 19-year-olds to drink some kinds of alcohol. In some states, people were allowed to drink beer with a 3.2% alcohol level before they could drink stronger beverages. In 1984, Congress decided to withhold federal highway funds from states that refused to raise the drinking age to 21. By 1996, all 50 states and Washington, D.C. had set the drinking age at 21. How did a policy that originally differed by state become a single national policy? And why did the winning policy move in the direction that it did? The answer has to do with federalism. Now, we're going to define sovereign power here as the amount of authority and autonomy given to each unit of government. And the question is, or actually the conflict is, who gets sovereign power? Under federalism, both the federal or national government and the states have sovereign powers. It's a matter of balancing federal power with the power of the state. In this case, Congress cannot create a national drinking age. But Congress can play its role in the power of the purse to withhold federal highway funds from non-compliant states that don't abide by the policy. So in reality, Congress, because it has the power of the purse in funding highway systems, has the ability to dictate the success of a policy. To see how federalism works in context, let's begin by remembering the basics of federalism. In the United States, the federal and states government each have separate powers, and they also share some powers. For example, state governments are not responsible for national defense or foreign policy, while the federal government is not responsible for determining whether or not you're allowed to smoke in a bar or a restaurant. It is important to note that with respect to divided power, we only refer to federal and state governments. Local governments are creatures of the state government and do not have their own powers. Their powers, called police powers, are given to them by the state. Recall that dividing powers between national government and states governments is a central issue of the Constitutional Convention and even of the Civil War. But how do these issues affect you today? Some ways in which federal power might affect today's college student would be land-grant universities, work-study jobs, federally guaranteed student loans, Pell Grants. Controversial questions about congressional power should also include such things as, should Congress be able to provide employer discrimination based on age or disability? Should Congress be able to compel gun bans around public schools? Can Congress set nationwide penalties for violence against women? The underlying question then becomes, should governance in the United States be more nation-centered or state-centered? Now, in regards to sharing power, we have separate powers and concurrent powers. State governments, for instance, have separate power for conducting elections, promoting public safety, and police powers, while the national government has separate powers for national defense and foreign policy. Concurrently, both the state and federal governments have the ability to collect taxes. So those are concurrent powers. Unitary systems are about 4 times more common in the world than federal systems, largely because they have a simpler power structure and avoid disputes between different levels of government. Though it is less common, an advantage of federalism is that it helps countries deal with ethnic or ideological differences within their population. For example, Canada's federal system provides French Canadians with autonomy in the province of Quebec, where most everybody speaks French. In a confederal system, the states have more power than the central government. Though there are historical examples of confederal systems, such as the United States before the ratification of the Constitution, and the Confederate States during the Civil War, few modern examples of confederal systems exist. The national government under a confederal system is so ineffective and it creates so many problems that it's unable to last for a long term. The preamble to the Constitution opens with the words, "We the people of the United States." When we compare that to the Articles of Confederation, which opened with, "We the undersigned delegates of the states," you can see an early sign that the founders intended to have a less state-centric government under the Constitution and a government that was more under the control of the people, popular sovereignty. The Necessary and Proper Clause, which is found in Article 1, Section 8 of the Constitution, and the Elastic Clause, or it's called the Elastic Clause, gives Congress the authority to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. While enumerating Congress's powers, the Elastic Clause also leaves the door open for Congress to expand the scope of conflict, as it can point to this clause whenever it passes legislation that might not directly relate to the powers enumerated for the Congress. The Supremacy Clause, which is part of Article 6 of the Constitution, states that the Constitution is the supreme law of the land, and that judges in every state shall be bound thereby, anything in the Constitution of laws of any state to the contrary notwithstanding. So that means that federal law trumps state law, bottom line. Enumerated powers are those powers that are given specifically to Congress, such as admitting new states to the Union, declaring war, coining money, creating and maintaining our armed forces, and regulating commerce with American states and with foreign countries. The 10th Amendment says that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people, which is often referred to as a Reserved Powers Clause. The 10th Amendment says that any power not explicitly given to the national government is reserved for the states. The 11th Amendment prevents citizens of one state from suing the government of another state, and it was passed in reaction to a case called Chisholm versus Georgia in 1793. It's often used by states to exempt themselves from lawsuit, as we'll see in a minute. Jim Obergefell, the plaintiff in the case of Obergefell versus Hodges, was a Supreme Court case that legalized same-sex marriage nationwide and it was backed by supporters of the ruling on the steps of the Texas Capitol here during a rally on June 29, 2015 in Austin. The ruling shows the power of the Supremacy Clause as it has struck down laws in 14 states, including Texas. Concepts that support both nation-centered and state-centric perspectives are the Privileges and Immunities Clause and the Full Faith and Credit Clause. The Privileges and Immunities and Full Faith and Credit Clause basically say that a person is entitled to all the privileges and immunities of a state and full faith and credit. The states must give full faith and credit to the laws of other states. Now let's take a look at the evolution of federalism. From 1789 to 1937, federalism was in the form of what we call dual federalism, or as we'll see later, layer cake federalism. The characteristics of this type of federalism are that the national and state governments were viewed as very distinct, with little overlap in their activities or their services that they provided. Within this period, federalism could have been state-centered or nation-centered, but relations between levels of government were limited, so what you had was like the layers of a cake with frosting in between. You had a layer cake type of federalism. Cooperative Federalism, which is often termed marble cake federalism, started in 1937 in the middle of the Great Depression and continues till today in a lot of respects. This indicates greater cooperation and collaboration between the levels of government. The two levels of government have to communicate with each other and work together. Fiscal Federalism, which again from 1937 to the present, starting in the Great Depression, the system of transfer payments or grants from the national government to lower level governments involves varying degrees of national control over how the money is spent. You have categorical grants, which give the national government a great deal of control, and block grants, which have less national control and more state control. So states like block grants, and the federal government, federal bureaucracies, if they want to impose a policy over the states, like the categorical grants. Picket Fence Federalism, which started in about 1961 till present, is a version of Cooperative Federalism that emphasizes that policymakers within a given policy area have more in common with others in their area at different levels of government than with people at the same level of government who work on different issues. New Federalism, which goes from 1969 to the present, attempts to shift power to the states by consolidating categorical grants into block grants and by giving states authority over programs such as welfare. But the states also have to accept more responsibility. Coercive Federalism, which starts in the 1970s and goes to the present, involves federal preemptions of state and local government authorities and underfunded mandates on state and local governments to force the states to change their policies to match national goals or policies established by the Congress. Under coercive federalism, the national government is using its power of the purse, as in the case of the drinking age or the case of seatbelt laws. They use highway funds in order to coerce the national government into a policy. In the early 1800s, the Supreme Court confirmed the national government's right to regulate commerce between the states. The state of New York granted a monopoly to a ferry company that served ports in New York and New Jersey, but this was found to interfere with interstate commerce and was therefore subject to federal intervention. After the Supreme Court struck down the 1875 Civil Rights Act, Southern states were free to impose Jim Crow laws. These state and local laws led to compel racial segregation even for public drinking fountains, restrooms, movie theaters, and so forth. Franklin Delano Roosevelt's New Deal shifted more power than ever to the national government. Through major new programs to address the Great Depression, such as the Works Progress Administration, WPA, construction projects pictured here, the federal government expanded its reach into areas that had been primarily the responsibility of state and local governments. Now, here is a explanation of Picket Fence Federalism. As you can see, your pickets are your different planks, different policy areas: agriculture, environment, highways, housing, education, medical care, and tax policy. And then across those pickets goes the national government, the state government, and the local government, who may or may not have to work together. They each have different responsibilities, and they have to work, hopefully together, cooperatively, in order to have picket fence federalism. Advocates for smaller government often make the argument that spending in Washington is out of control and that state and local governments should have more power. What do the numbers say here? What are the trends in state and local spending as a share of the total economy compared to federal spending? As you can see, state and local spending still, while it's going up, it goes up along with federal spending. And grants have been going up as a proportion of state and local spending as well. So categorical grants are grants of money to states with strings attached, what I like to call the carrot and the stick. Block grants are money to states over which states have more discretion. So if you're the federal government, you like categorical grants. If you are the states, you like block grants. In any way, in any perspective, grants since 1947 have increased. State and local spending has increased. Federal spending has increased. In American politics, we tend to reinforce our desire for a strong national government. Crisis and war. After the terrorist attacks of September 11, 2001, Americans expected the national government to improve national security. When states violate the civil rights of their residents, the national government often steps in to guarantee equal treatment of citizens. So there's a need for strong government with regard to crisis and war, and with regard to responding to the violation of civil rights. Coercive federalism is a way of preempting state power. In the past 20 years, the states have become more active in policy innovation. Trust in state governments is often higher than trust in national government, and states have passed a number of policies that are more progressive than the national governments. This includes policies on fighting pollution through stricter emission standards and renewable energy grants in California, extending state benefits to children of illegal immigrants in some states. Other states have passed more conservative policies than the national government, such as Arizona's immigration policy, or Kansas's voter ID laws, and Texas's voter ID laws for that matter, which require proof of citizenship to register to vote. Competitive federalism is competition among the states to provide for the best policies to attract business. Some call this a race to the top. Some call this a race to the bottom. Competitive federalism can be a good thing as it allows people to what they call vote with their feet. But critics have also said that it can lead to a race to the bottom, whereby states compete in unhealthy ways to lead to social ills. The Lopez decision struck down the 1990 Gun-Free School Zones Act, ruling that Congress did not have the power to forbid people to carry guns near schools. After the shooting of 12 students and one teacher at Columbine High School in Jefferson County, Colorado, on April 20, 1999, there were renewed calls nationwide for strengthening gun laws. Aside from the interpretation of the 10th Amendment and the Commerce Clause, grassroots advocates are using that grassroots advocates are using to defend laws protecting gun owners and pot smokers, other strategies are being used to shift federalism towards states' rights. In several cases, the Supreme Court has ruled that states could not be sued, even if they violate anti-discrimination laws, because of the 11th Amendment. The 14th Amendment was supposed to let the federal government address potentially discriminatory state laws. However, in recent cases, the Supreme Court has also created a new, higher standard required to justify remedial legislation. Remedial legislation means national laws that address discriminatory state laws. The Commerce Clause is often used in conjunction with the Elastic Clause to allow the federal government to create legislation and or intercede with state laws in excess of those that are in enumerated powers. Spending per person varies dramatically by state. What are some of the advantages and disadvantages of living in a low spending state or in a high spending state? Well, you got to consider that high spending states are generally going to, unless they're getting their money from the federal government, which would be income taxes, they're going to have heavy taxes. So that's a trade-off. Texas is a relatively low spending state per capita in comparison to other states. New Mexico, while it has a smaller population, is a high spending state. California is a relatively high spending state. Florida is a very low spending state. You can see it in the blue there. Oregon is a relatively low spending state. High spending state. Whereas New Hampshire is a relatively low spending state. Rather than being either purely good or bad, federalism and state powers have different trade-offs. Consider the policy innovation of public smoking bans, medical marijuana, seatbelt laws, or mail-in ballots, all of which have emerged as state policies. What are the benefits of allowing states to become laboratories of democracy? Is there a way to encourage this policy innovation while preventing states from violating the rights of other citizens, leading to what we call a race to the bottom? Well, here are the benefits. The benefits are more policy innovation, more policy responsiveness, more pathways to responsiveness, and checks on national tyranny. The costs are unequal resource distribution, unequal civil rights protections, and the ultimate race to the bottom. Now let's look at how it works for this particular chapter. Layer cake federalism meant no interaction between, or little interaction between, the levels of government. National government on one layer, state on another layer, local on another layer. And remember, local power comes from the state power anyway. Marble cake federalism mixes state, local, and national power together. And we started to see that from 1937. And it requires interaction and cooperation between the levels of government. Picket Fence Federalism is horizontal boards representing different levels of government and pickets that are the policy areas within each coordination happening across those levels, like agriculture, environment, highways, housing, education, medical care, and tax policy. So what you see is departments for each of these at the state and national levels. Now, Coercive Federalism, going from the 1970s till today, says that the national government uses regulations, mandates, and conditions to pressure states to fall into line with national policy goals. And it requires the use, basically, of the purse, withholding money to those states that don't do what the federal government wants them to, and giving money to states that abide by federal policy. Here's your layer cake federalism. National level on one, state level on another, local on another, no or little interaction between them. Here's marble cake federalism. Heavy levels of interaction between the levels of government, they're common, and everything's mixed up into a marble cake. So instead of having chocolate, vanilla, and strawberry in layers, you mix it all together. Picket Fence Federalism. Horizontal boards represent different levels of government. Pickets are policy areas within which coordination happens across those levels. So your pickets are agriculture, environment, highways, housing, education, medical care, tax policy, and so forth. You can have a variety of these pickets. And then your posts are at the national level, state level, and local level. So there's a lot of interaction. Coercive federalism is the use of regulations at the national level to withhold money or grant money to states in order to get them to do what the federal goals are for policy. Now, let's look at who carries out environmental policy. At the national level, it's the Environmental Protection Agency, the Department of the Interior, and the Department of Energy. At the state level, it's the State Department of Natural Resources, State Park Services, State Environmental Protection Agencies. Each state has these agencies. At the local level, it could be city parks, city and county oversight boards for land use policy and zoning. Our city has a group of people that go around in trucks that are environmental services that are looking to make sure that grass is mowed and trash isn't out on the streets and so forth and so on. In short, the federal government imposes new rules on states and local governments and provides incentives to follow those new rules and goals. Goals such as increased energy efficiency and independence can be motivated either by, I'm going to write with my mouse here, the carrot or the stick. The stick is withholding money. The carrot is granting money. Either way, the policy is to get, for instance, wind farms to expand within a state. Now let's look at a case called Gonzalez v. Rake. In Gonzalez v. Rake of 2005, Ms. Rake was growing marijuana for medicinal purposes, which was totally legal in the state of California as long as you had a medical marijuana card. The marijuana she grew was for personal use, but federal agencies burned all of her weed. Ms. Rake thought that was what the federal government doing was illegal, so she took it to court. Is she right? Well, let's see what the court said. The court found in favor of the federal government, citing the need to control the manufacture and distribution of Class I narcotics, which marijuana is considered to be. The Supreme Court found against Angel Wright and her in favor of the federal government's power to regulate and seize marijuana, even if it was legal in the state of California. Now, you may agree or disagree with this. We've seen a lot of states put in medicinal marijuana laws and even recreational marijuana laws, but you've got to remember that those laws are only good as long as the federal government doesn't decide to step in and enforce its laws. This would be the DEA seizing marijuana plants from a medicinal marijuana lab, a medicinal marijuana pharmacy. They seize the plants and burn them. They can do it because even if the state law says it's legal, federal law says it's illegal. Now, in Hurricane Sandy, the relationship between the national government and the states also involves cooperation. After unprecedented flash flooding devastated South Carolina in October of 2015, FEMA partnered with state officials to provide relief at outposts like this one. And so we learned from Hurricane Sandy, we learned from Hurricane Katrina, that FEMA has to step in and help, that we look to the federal government in times like that to assist the states. In the debate over health care reform and the Affordable Care Act, or Obamacare, supporters of nationalized health care have argued that the federal government could do a better job than the patchwork of state policies that have happened over the years to ensure that all Americans receive sufficient care. One of the strengths of federalism is that it allows regional diversity to flourish. The Green Bay Packers fans proudly wear their cheesehead hats at Lambeau Field, showing that what passes for normal behavior in one part of the country would be viewed very differently at another. I don't know if in El Paso at UTEP you would go at your UTEP game and wear your cheesehead hat. The Americans with Disability Act of 1990 requires that public accommodations and commercial facilities be accessible. The recent Supreme Court rulings have held that the law does not apply to most state and local government buildings. Here, activists for the disabled community are shown in front of the White House lobbying for stronger legislation. With the No Child Left Behind Act, the Bush administration increased the national government's power over education. This law was replaced by the Every Student Succeeds Act in 2015, which provides more flexibility to states to meet the needs of their students. But it still requires testing and meeting goals. All right, so now let's look at national and state responsibilities. The national governmental powers, again, as I stated before, are to print money, regulate interstate commerce and international trade, make treaties and conduct foreign policy, to declare war, to provide an army and a navy, to establish post offices, to make laws necessary and proper to carry out those powers. State governmental powers are to issue licenses, to regulate interstate businesses within the state, to conduct elections, to establish local governments, to ratify amendments to the Constitution, to promote public health and safety, and they may exert powers that the Constitution does not delegate to the national government, nor does it prohibit to the states from using. Those are state powers. Concurrent powers are things like collecting taxes, building roads, borrowing money, establishing courts, making and enforcing laws, chartering banks and corporations, and spending money for the general welfare, taking private property for public purposes with just compensation, the Fifth Amendment. Powers denied the national government. The national government may not violate the Bill of Rights, may not impose export taxes among states, may not use money from the Treasury without an appropriation from Congress, may not change state boundaries. Powers denied to the state governments: they may not enter into treaties with other countries, they may not print money, they may not tax imports or exports, they may not interfere with contracts, and they may not suspend a person's rights without due process. That's 14th Amendment. Let's look at some landmark Supreme Court cases on the issues of federalism. Chisholm versus Georgia in 1793 held that citizens of one state could sue another, and led to the 11th Amendment, which prohibited such lawsuits. And that gave the states less power. McCulloch versus Maryland in 1819 upheld the national government's right to create a bank and reaffirmed the idea of national supremacy, which again lessens state power. Gibbons versus Ogden in 1824 held that Congress, rather than the states, had the power to regulate interstate commerce. That again lessens state power. Barron versus Baltimore, 1833, endorsed the notion of dual federalism, in which the rights of a U.S. citizen under the Bill of Rights did not apply to that of the same person under state law. That increases state power. Dred Scott versus Sanford in 1857 sided with Southern states' view that slaves were property and ruled that the Missouri Compromise violated the Fifth Amendment because making slavery illegal in some states deprived slave owners of property, which contributed to the start of the Civil War. It gave the states more power. This is the one that said a slave had to be returned to the state from which they came. National Labor Relations Board versus Jones and Laughlin Steel Corporation in 1937. This is a more obscure case. Upholds the National Labor Relations Act of 1935 as consistent with Congress's Commerce Clause, reversing the court's more narrow interpretation of that clause, which makes less state power. So as you can see, the federal government has won, out of the 6 cases here, 4 of them. Now let's look at recent Supreme Court cases. Gregory versus Ashcroft in 1991. The Missouri Constitution's requirement that state judges retire by age 70 did not violate the Age Discrimination in Employment Act, gives more state power. United States versus Lopez in 1995, which I already mentioned. Carrying a gun in a school did not fall within interstate commerce. Thus, Congress could not prohibit the possession of guns on school property. More state power. Seminole Tribe versus Florida in 1996. The court used the 11th Amendment to strengthen state sovereign immunity, ruling that Congress could not compel a state to negotiate with Indian tribes about gaming and casinos. More state power. City of Bernie versus Florida, 1997. The court struck down the Religious Freedom Restoration Act as an overly broad attempt to curtail the state-sponsored harassment of religion, saying that national legislation aimed at remedying states' discrimination must be congruent and proportional to the harm. Again, more state power. United States versus Morrison, 2000. The court struck down part of the Violence Against Women Act, saying that Congress did not have the power under the Commerce Clause to provide a national, a national remedy for gender-based crimes. Lost my place. Alabama versus Garrett. The court struck down the portion of the ADA, or Americans with Disabilities Act, that applied to the states, saying that the state governments are not required to make special accommodations for the disabled. More state power. The Nevada Department of Human Resources versus Hibbs, 2003. The court upheld Congress's power to apply the 1993 Family Leave Act to state employees as appropriate legislation under Section 5 of the 14th Amendment. Less state power. United States versus Bond in 2011. The court upheld an individual's right to challenge the constitutionality of a federal law under the 10th Amendment. More state power. National Federation of Independent Businesses versus Sebelius. The court upheld most provisions of the ACA, but struck down the expansion of Medicaid as an unconstitutional use of coercive federalism. It said that the states could voluntarily take the additional funding to cover the expansion, but they could not lose existing funds if they opted out. And that's mixed in the direction of the decision. Texas opted out of expanding Medicaid. United States versus Windsor. The court held that Section 3 of the DOMA, or the Defense of Marriage Act, was unconstitutional because it denied federal benefits to same-sex couples who were legally married under state laws. More state power. Shelby County versus Holder. The court struck down Section 4 of the Voting Rights Act on the grounds that it violated the equal sovereignty of the states. More state power. So here, as you can see, the trend in the past 20 years or so has been giving more power to the states, less power to the federal government. Whereas prior to that, the trend was giving more power to the federal government, less power to the states. And that ends our lecture for this chapter.